With the approval of the final version of the new standard contractual clauses and of the recommendations of the European Data Protection Board on data transfers, any business is now convinced that a transfer impact assessment will be a step necessary for transfers outside the European Economic Area, and that there will be no solution, easy solution that might bypass that step. Indeed, Article 14 of the new standard contractual clauses expressly refers to the need to perform a transfer impact assessment and to document it. And the recommendations of the European Data Protection Board reiterate the need to perform such assessment, even though the new standard contractual clauses are in place, even though the BCRs are in place. The only exception is applies only if the transfer is towards a country that ensures an adequate level of protection in line with EU standards. In order to support companies in running such exercise, at DLA Piper, in the aftermath of the Schrems II case, we developed a methodology that is then supported by a legal tech tool named Transfer that automates the transfer, the assessment. So the methodology and the legal tech tool is based on 4 pillars. First of all, we need to nail down the elements of the transfer. The assessment that will be produced needs to be a document that can be in the same file as the contract regulating the transfer. So we outline who are the parties, what are the data importing countries, what kind of data are transferred. Then the second stage is we need to assess the laws of the importing countries. There might be more than one country involved, and so we will have multiple assessments. And in this task, a fantastic support is given by our colleagues of non-EEA countries. With DLA Piper, we can cover basically any country worldwide together with also our best friend law firms. And so we produce for our clients an annex covering the laws and the practices of the data importing country, together with a scoring tool identifying how wide is the divergence from the GDPR. The third element is to assess what kind of supplementary measures have been adopted. They can be contractual, can be organizational, they can be technical. But also on this task, we support our clients because we provided an annex that outlines the additional contractual clauses that can be embedded into the contract and provide the support necessary to reinforce the data transfer and the compliance of the data transfer with EU standards. That annex can be adjusted to the peculiarity of the case, to the level of risk, so just basically on the specific needs, and also the weight of these additional clauses is then that is then embedded into the legal tech tool with a specific scoring. The third element analyzes the peculiarities of the data transfer in line with what outlined by the European Commission in the standard contractual clauses. The specific characteristics of the data transfer need to be specifically tackled, and they trigger an additional score. The final result is a total score that is giving you a recommendation as to whether you can proceed with the data transfer, you can need to implement additional measures, or the transfer cannot proceed, all in the light of the accountability principle. The good element is that this methodology and legal tech tool has been showed to data protection authorities of the main countries within the European Union that appraised our effort to automate, to make easier this assessment, and then we adjusted the assessment, slightly adjusted, honestly, to the new standard contractual clauses and the new recommendations of the board in an assessment that in any case needs to be a risk assessment. And so with our assessment, we believe that our clients are in a position to better defend their position towards authorities.